In just a moment. Welcome, appreciate you being here. Eric Johnson is going to get us kicked off with some words of welcome. Then we'll talk through the objectives for tonight, a little bit of background, objectives, and agenda. Then we'll dig into any questions that you have. Mindy Kemp is going to deliver APS 101, the basics of how the Adult Protective Services system functions. And she'll weave questions in, and then we have about a half hour at the end for questions and answers. Fair enough? Eric, if you would.
Hi, I am Eric Johnson. I'm the Deputy Director of the Office of Community Access and Independence, which is the office that oversees the APS program at the state level. As Greg said, the main purpose of the meeting today is to give more insight into how the APS program is run statewide, to hopefully alleviate concerns that have been expressed about the program, but also to give you the opportunity to ask questions and hopefully provoke a dialogue that hopefully will lead to a better understanding at the end of the meeting. We encourage you, once we're through the presentation, ask whatever questions you have. And we really want this to be a very informative session for you, and we hope that that's the way it turns out for you. Thanks.
Okay. So, a bit of background. We'll do introductions here in a moment. Before we do, a bit of background. House Bill 17-1284 created a requirement for certain employers to request background checks of the APS data system prior to hiring someone that's going to provide direct care to at-risk adults beginning on January 1st, 2019 and forward. Along with that comes an obligation for CDHS to promulgate rules to implement that legislation. CDHS will be presenting 2 additional rule packets in the next 4 months to the State Board of Human Services. And this is the first of 3 stakeholder meetings this month. This first one, as Eric said, has a goal of building awareness about the APS program. On March 13th, that's next Tuesday, we'll receive feedback on draft rule packet 2. And toward the end of the month, on the 28th, will be a discussion around draft rule packet 3. Okay? A bit of background for you. So as Eric said, our goal tonight is to raise awareness of how the APS system is structured and operated. That includes a bit of information on legal foundations, the protection framework, the relationship between the counties and the state, and then roles and responsibilities. So how we'll do that, a little bit of opening, and we're going to do introductions and then solicit from you any additional questions. And the method here is, if we understand the questions in advance, Mindy can weave that into her presentation, and we'll cover more ground in a shorter amount of time. As I mentioned, there's about a half hour toward the end for question and answer on any topic that might have occurred to you during Mindy's presentation, and then just a few more minutes to recap what's coming for the rest of the month. Good enough to go on? Cool. So, a couple of ground rules. First, I'll manage the session. Kudos to you all last time. I think you did a nice job of making room for each other. Appreciate that. We'd like you to continue to demonstrate your respect for all participants by doing 4 things. First, silence your mobile device. Second, please be succinct. There are many people who care about this, and so if you can get to the point, that'll allow us to cover more ground. 3, make room for all to participate. So if you've spoken a bunch and there's somebody else waiting, again, I'll direct that, but appreciate you being a partner. And finally, consider varying opinions. Tonight especially is about relaying information and better understanding how the system works. So now would be a good chance to ask your questions and learn a bit about that. If you have any concerns, raise your hand. We'll take a short break right in the middle. You can approach me at that point or raise your hand at any time. Large groups via teleconference is a crappy arrangement. It just is, and so a couple more guidelines. So please, everybody, have patience with the technology. We're operating a webinar as well as this teleconference. For those of you in the room and on the phone, please repeat your name each time you speak. That'll help everybody know what name goes with which voice. For those in the room, please limit your crosstalk, paper shuffling, etc. It's very frustrating when you're on the telephone to hear such things. For those of you who are on the phone or computer, please signal your desire by interjecting Or in the meeting application, you can effectively raise your hand, and Peg is monitoring that. She'll tip me off that you wish to speak. And then if you're not speaking, though, please use mute for the same reason. It just makes it easy to maintain focus if we don't have a dog barking in the background and so on. Okie doke. So we'd like to do some introductions. As you do so, I'd like you to actually do two things. First, share your name and organization if you are affiliated, and then ask any questions that you'd like to see addressed today. We've received a list of 12 in the last 3 months. We just put up some posters of those for you to be able to see which ones have already been received, and Mindy will weave those into her presentation. But if you have one that you don't see up on that list, or for those of you on the phone who can't see the list, go ahead and ask it. I'll record it, and Mindy will do her best to weave that in. If we miss something, that's what that second half of the meeting is for. All right? So we'll start in the room. Jim T., if you wouldn't mind.
My name is Jim Teton, and I have an interest in the process for a number of reasons. The first is, about 10 years ago, I suffered a severe traumatic brain injury. And so I have invisible disabilities that are hard to explain to others and hard to describe in terms of other people's identification with it. Prior to my injury, I was on the board of Advocacy Denver for about 17 years. And I am here representing myself to learn more about the rulemaking process, and I have a particular interest in some of the concepts that appear in the questions, like standards, due process. We've heard a lot of discussion about that in the legislature over the past couple of weeks. Those are important.
Great. Quick sound check. Those on the phone, were you able to hear Jim okay?
Yes.
Thank you.
Fine.
Thank you very much. Maureen.
Yes, my name is Maureen Welch, and my son James is here in cardboard form as well. I live in Arapahoe County. I have 2 master's degrees, one in education, one in special education, and I worked in large school districts here in the Denver area. I am very concerned about APS, and thank you for having the meeting today. My 2 questions that I don't see on there, actually, one of them came into me today, and they preferred that I brought it, and that is, it's an agency asking if there's some sort of process flow sheet on how to report and who to report to. There seems to be none, and that goes back to my concern about 64 different ways of doing it, because every county seems to be doing things differently. And then the other one was something I've voiced in several meetings, but it's not on the list, and that is, we in the community want a safe way to communicate about cases, and right now there's no safety. There's a lot of concern about retribution, and the question is, where do people go that's safe to discuss a case that they're concerned with? Right up there it says to call Salisa, who's a very nice lady I talked to last meeting, but it's kind of like, I don't know if any of you saw that movie that's out now with Winston Churchill, The Darkest Hour, but it's kind of like he said in the movie, you can't negotiate when your head is in the mouth of the tiger. And to go to the same organization that is investigating and has the power is not a safe place. So where do we go that's safe to discuss particular cases? Thank you very much.
Thanks, Maureen. Rob?
Yeah, my name is Rob Hernandez, and I've got about 10 years experience as a host home provider and as a former legislator, and with Senator Smallwood is now chairing the Committee on Senate Services, which I chaired while during my tenure in the state legislature. And I also have a master's degree in healthcare policy and rule and regulatory. So these are type of issues that I really like diving deep into and getting into great detail about. But I do have a couple of concerns that I still haven't. You know, we've heard preponderance of evidence a lot, and that's question number 7. And I guess there's more sub-questions to that, because what's the criteria for preponderance of evidence? It seems like there's 64 counties versus everybody's different way of interpreting that. And when I went before the rulemaking board, said, well, you have 100 legislators over there grappling with what does that mean? how do we come to that determination? What does preponderance of evidence mean? Because there's really nothing in statute in APS that really defines that. And so what's the criteria for that? What are its elements, how it breaks down? And when APS goes through training and you look at the PAW, and Maureen, correct me if I'm wrong, the PAW stands for the preliminary
Pre-academy
workbook. And when it's referred to in there, there's no definition of what it is. It just explains it. We've determined there's a preponderance of evidence, so therefore we substantiate you, and then you go into the blacklist, which is now the registry. So there's a lot of concern about that. Is how do you define that? And Jim last time referred to a perpetrator. That's a term used in criminal law, but apparently APS agents throw this term around as if you've already been tried guilty and now need to be executed for your wrongdoings. And there's no due process now. That's another concern. So we know that preponderance of evidence is not being brought about or determined consistently because there's no specifics to it that need to be attached to it. So, and the other thing that's not on there is in the training in the PAW, in the preliminary workbook, is that it says in there specifically, and I have a slide, I don't know if I brought it with me, but it says that emergency room visits are considered harmful. So there's one family member that took the sister took her family member to the emergency room. 3 doctor's orders to prove that. But yet APS refused to look at it and said, no, you're the perpetrator because you took him to the emergency room. But 3 doctors' orders said, this is what you do in this situation, and APS ignored that. So why is that considered harmful when you have IDD individuals, people with intellectual developmental disabilities? They all have chronic conditions, every single one of them, whether it's mental health or whether it's physical. So when a doctor's orders or a surgeon or a hospitalist or an emergency room physician or a PCP comes back and said, I want you to take him to the emergency room when this particular issue arises. And when a family member does what they're told, but APS then steps in and then jumps in and removes the individual from the home on that basis alone. And there's a case like that where that's still ongoing and APS refuses to look at the evidence. Well, we don't look at doctors, we're just here to look about guardianship or whatever it is that they're doing. So they won't listen to the family or they won't listen to the IDT team. So there are some problems with definitions that are being utilized by adult protective services workers because we don't see any consistency. And I know, Mindy, you said that they're consistent, but we have evidence to the contrary. So those are some of my concerns. But thank you for listening.
Thanks, Ron. Ann?
You bet. Thank you. My name's Ann Meyer, and I serve as Colorado's State Long-Term Care Ombudsman. I work at Disability Law Colorado. The Ombudsman program is there to serve as a complaint resolution service directed by residents in long-term care settings, which means assisted living and nursing homes. We last year also added a program that protects and promotes the right to care, right to quality of life for people who are participating in PACE. I don't have any particular questions, but I'm pleased to be here and pleased to be part of the discussion.
Thank you very much. Jens?
Us?
Please, sorry.
You're in a shadow, we can barely see you. How's it going? I'm Jim Smallwood. I'm State Senator for Colorado Senate District 4, which is most of Douglas County, geographically anyway. I'm joined by my aide, Andrew Nahr. Unfortunately, we are not going to be able to stay nearly as long as we'd like to tonight. We're just trying to get our arms around what the process looks like, how people go around making policy, promulgating rules around this topic. I'm the chair of the Health and Human Services Committee. I'm the vice chair of the Finance Committee, on the Business, Labor, and Technology Committee. I'm on the Legislative Audit Committee, and I'm on the Child Fatality Review Team. So thanks for coming out and having us.
Thank you.
And when we slink out, it's because we have another commitment. I apologize. We learned about this a little later on, so appreciate it.
Heidi?
I'm Heidi Haynes. I'm the Director of Advocacy at the ARC of Colorado. There's that. Cristiano, do you want to?
Hi, Cristiano Sosa, ARC of Colorado.
Hi, Cristiano. How about you, Ann?
Me?
Yes.
Okay, I'm Ann Patton, and I'm a parent and an advocate in the community. I also have a couple of friends that have been involved in APS incidences, and I'm just kind of here as an interested party to keep a watchful eye on making sure that the rules protect individuals' rights, and families' rights. So, I guess that's all I have to say.
I'm Coral Cosway. I'm the Director of Public Policy and Advocacy at the Alzheimer's Association here in Colorado. And I just want to thank DHS and Mindy we were very excited when this bill passed. We have families who have concerns about the staff that's taking care of their loved ones sometimes, not most of the time, but in certain instances they do. And we feel like this bill and the new regs, obviously the devil's in the details, but that will go a long way in protecting the folks we serve. Our folks not only are elderly, but also have dementia. So a lot of times they can't, it's harder for them to be able to verbalize what's happening. So we appreciate the fact that we come from the other side of the coin, which is protecting vulnerable adults who are in facilities and wanting the people providing care to them to be providing the minimum level of care that they deserve. So thanks.
Thank you.
I'm Whitney Nettleton. I'm the program manager for APS in Denver County. I don't have specific questions either. I'm just here happy to take part in the conversation. I also have to duck out early, so I apologize that I'm not going to be able to stay the whole time, but looking forward to being here for what I can.
Great. So Peg has pulled up, for those of you on the phone, check the webinar. Peg has pulled up the list of questions here, but we'll go ahead and go to the phones. This is sometimes a little chaotic because I don't have a good way of signaling each of you, but let's go ahead. If you would announce yourself, if you wish to announce yourself, and then any questions that you have.
This is Mark Webster, and I'm the Director of the Office of Community Access and Independence at the Colorado Department of Human Services. And so I don't have any questions, but I'm glad everybody is there and looking forward to our overview of the program.
Thanks, Mark. Who else do we have on the phone?
I'm Jerry Fermi. Can you hear me?
Yeah, Jerry, we can hear you just fine.
Okay. Okay, because I don't seem to have the ability to mute my phone. And also on the webinar, there's a box that we type in questions and send, but it doesn't seem to be working. So whoever works on that, maybe they can fix that. I mean, when you try to type in a question, nothing appears.
Yeah, it's not coming across, Jerry. So just interrupt, and I'll make sure we go to the phones in equal proportion. Are there any questions, Jerry, that you have in addition to the ones that are up on the screen?
No, that's fine for now, and hopefully I won't make noise because my phone doesn't seem to be able to mute.
Okay. All right. Well, thank you. Who else do we have on the phone?
This is Lisa Franklin. I'm with Parent to Parent of Colorado, and we support families who have children with disabilities, adult children and school-age children across the state. And we've had multiple questions and concerns from families about both how they interact with the APS system, as well as if they have a concern about abuse, how they go about reporting that. So I'm primarily concerned in how this is going to happen consistently across the state.
Okay. Thank you, Lisa. Any others?
Can I just share something? There's quite a few people on the phone that don't feel safe enough to say that they're listening, but they are listening. So I just want you to know that that's the level of concern in the community, so that they are able to hear and everything. So thank you. Great.
And if any of you who wish to remain anonymous wish to send a text to Maureen or any of the others in the room, you're free to do so. Cool. So we've gotten through an initial list of questions. We're right about on time. So what we're going to do is Mindy will do her best to weave the answers to those questions into the presentation that she built. And it's either in the material or it'll be in the voiceover. And For those of you not able to join the webinar, the material is out on the web, is it not?
It's on the public meetings calendar.
Public meetings calendar. Thanks. Okie doke. Well then, Mindy, let's take it away.
Got me, let me start here. Skip it to 36. Okay, hi everyone, good evening. I have to get out of line a little bit. Thank you all for joining us today. I really appreciate everyone taking the time to be here and providing your questions in advance. It gave us a good opportunity to kind of build an APS 101 that meets the needs of the questions and the issues that have come up over the past couple of months. I asked Peg to skip ahead. We have some handouts in the room, and like Greg said, on the public meeting calendar, the PowerPoint for tonight has included as an attachment there. But I wanted to start sort of with the end in mind. We are going to walk through the APS program, but I hear a lot of questions about the CAPS check bill. So I kind of wanted to start there and frame the discussion, and then we'll kind of jump backwards. So this bill was passed last year, 1284. Our department, CDHS, was one of the folks that worked on it, but there were a lot of groups in the community that also supported this bill. And essentially you can see this is the legislative intent for it here, straight from the statute. But I think the General Assembly acknowledged that there are individuals that are receiving care from persons employed in facilities and programs that are vulnerable to mistreatment. And so the intent of this was to minimize the potential for employment of people with a history of mistreating at-risk adults and positions that would allow them unsupervised access. And so essentially what this bill did, it's there's a lot of components to it, but the main requirement in the bill is that starting January 1st, 2019, certain types of providers, when they're hiring somebody who will provide direct care to at-risk adults, are going to be required to request from the department a check as to whether the individual they're going to hire has been substantiated in an APS case. And one other component of this that I've heard some questions about due process. So previously and currently there is no due process for people who are substantiated in an APS case. But what this bill did is require the State Department, our State Board of Human Services, to create rules to create due process. So right now our department is working with the State Board and we've put forth some proposed rules for their consideration to add due process. And our intent is that starting July 1st, so a couple of months from now, there will be due process. And what that will look like is if you're substantiated in a case of mistreatment against an at-risk adult in an APS case, then you'll receive a notice that you've been substantiated and you'll have the opportunity to appeal. And so the rules kind of spell out what that appeal process looks like, what your options are, that sort of thing. And so only the substantiated cases will show up in a check. So for example, if APS has received a report and they go out and do an investigation and it's unsubstantiated, that will not show up on a CAPS check, only the substantiated. And again, once the appeal process is over, if somebody has been expunged, their substantiation has been expunged, then that will not show up in a CAPS check. So that's just kind of a quick overview. I think I would also point out that part of the reason why this came about is that our executive director, Reggie Vika, every summer does a summer planning tour. And so a couple of years ago, Reggie was out in his executive team and they were listening across the state. And they had listening sessions, and one of the things they heard more than once was that, I am concerned about at-risk adults, I'm concerned about vulnerable adults, and I happen to know that an individual mistreated somebody in a facility. They were fired from that facility, but now they work at another facility or a home care agency or another place where they would have access to vulnerable adults. And so partly what this does is try to prevent that situation from occurring and protect vulnerable adults.
And I would also add that there is a similar system on the children's side. So when somebody's being hired to work at a childcare facility, that childcare facility is required to request a check of our Department of the Trails database. And Trails is the database where child welfare findings reside. And so there is a sort of precedent for this in Colorado, in that it exists in the children's system. And I think when this bill was going through last session, several stakeholders testified that they felt like at-risk adults should have the same protections that children do. So, sort of a little of the background of that. I think I might pause there before I jump back into the APS 101 to see if there are any specific questions on what this bill does. And then I will just add that the rule process, we're in the process of that. All the rules have not been passed yet by the state board, but we've done a lot of stakeholder engagement, particularly with employers and provider groups that are going to be required to do those checks, right? They have a lot of questions about how will I have to do that check? What will that look like? So we've been holding some meetings with them over the past several months. And so before I move on.
Yeah, I have a question. So can somebody be substantiated without a criminal conviction?
Yes.
That's what I thought.
Yes. So APS does their own investigation. They can do it jointly with law enforcement, but there are some times where there is, criminal, investigation, or sometimes there's not a criminal conviction. Sometimes, sometimes there's a criminal case pending, but the APS team has gone in and done their full investigation and substantiated, and the criminal case is still going on. So and that's another reason I would say that some of the advocates were advocating for this bill is that not every case of mistreatment, is investigated by law enforcement or there's conviction, and so there is, that gap there, similar to the children's system. Again, similar concept that not every case of child abuse or neglect results in a criminal conviction or that sort of thing.
So, I know that. Unfortunately, that seems to happen far too often, that people can't get convicted. And so does that mean that APS isn't working closely with law enforcement then when these investigations are being handled, or?
No, I wouldn't say that. APS actually is required by statute to have memorandums of agreement with local law enforcement, local DAs, the local long-term care ombudsman, and the CCBs, in that they would define on a local level how they choose to partner with each other, and we have templates that we give them. But every effort is made to ensure that they're coordinating if they're doing a joint investigation. So, for example, if a report is made and law enforcement and APS are both, and my APS experts can correct me, but if they're both going out, they might want to choose to interview the at-risk adult together so that it's not, 4 interviews on one issue, that you have the APS person and law enforcement doing that at the same time.
So, and I guess I would just, what I continue to be concerned about it is the level of broad-based knowledge that APS has around people with developmental disabilities. So I think that can be a gap that's kind of hard to fill. You don't have a lifetime of living with that. So understanding that.
Thanks.
Yeah, I just was wondering if you could maybe clarify, Mindy, and maybe Peg too. The CAPS system exists, the CAPS software exists now, correct?
Yes, it's a database where the information is housed.
Right, and then the CAPS check is going to be more of the registry or a branch on the tree of CAPS, correct? One part of the CAPS will be the registry.
Oh, you're getting technical. Yeah.
Okay, the reason I'm asking is
I'm going to have to phone a friend.
I'll take that. So this is Peg Rogers. I'm the APS program manager. The CAPS data system is where we take and document all the reports that come into us, and then all of our investigation and the provision of services that we do. The CAPS check bill we'll have an area that will store the requests for the checks from the employers and our finding on that check. But the CAPS check, we'll be searching in the CAPS database. There is not going to be two separate databases.
Okay.
That's one of the things that got child welfare in trouble many years ago because they had a separate.
Okay, thanks for clarifying that. The other question is so if you're investigating some cases now, that information is in CAPS, and according to the rule, which I've read backwards and forwards, it's in there indefinitely to be used in future. Even though individuals can't have they won't be flagged in the CAPS check system, the registry system, all the information will be there and can be used against somebody in the future, correct? For a risk assessment. That's what I have a concern about, because you're collecting data on people in this CAPS system, and you're going to use that and say, oh, well, we can go back 5 years and find out what happened then. That's a big concern for me, separate from the registry.
That's not reportable to the employer.
Right, but it can contribute to a future investigation, correct?
It can contribute to a future investigation, and I would want to say to that, Maureen, is that you want that information to be available because you don't want someone who has mistreated John and mistreated Sally and now is mistreating Ron, right? You want that historical information so that APS and law enforcement know what it is that this person has had a pattern of doing.
Right, that's how you could use it correctly. There's also unintended consequences of a lot of reporting being done for retribution, but then in the future it could be used against an individual. So it could also be used the other way. So I just wanted to clarify that. A few people have confused the registry with the CAPS, and I'm trying to explain to them, CAPS will always exist whether there's a registry or not. And that's even more concerning for a lot of people, that you're storing all this data on that system that are unsubstantiated that can be used against a person in the future. Thank you.
But it also can be used to exonerate someone as well.
And we'll get into a little bit more when we circle back to the APS 101. Are there any other specific questions related to the CAPS check bill before we dive into the 101? Jim?
You know, I don't, my question is with regard to the language of substantial allegation. That seems to be a term that provides the basis for a lot of the discussion and concerns. And I'm trying to figure out what it is and how it's defined within, it's a burden of proof. And within civil litigation, there's 10 different burdens of proof. Does the use of the term substantial allegations for the purposes of the rules and regulations satisfy the legal definition of substantial evidence? And substantial evidence is defined as a finding of fact made by a jury or an administrative agency in the context of adjudication of formal rulemaking, and will normally be upheld on appeal unless unsupported by substantial evidence. This means something more than a mere scintilla of evidence. I mean, you know, I'm trying to figure out what is, I see the General Assembly's language up there, and so this is codified within that specific statute up there, the findings of facts and all that.
This is directly from this section of the statute.
The statute.
And I think what you're asking is a little bit to the question Rob asked earlier, and again, we'll circle back to this regarding the preponderance of evidence and how substantiated finding is defined in the APS rules and terminology.
Okay.
And
so those are consistent with other Colorado state agency rules. So
correct.
Substantial evidence means the same in one department as it does in another in terms of meeting the burden of proof.
So substantiated finding is defined in the APS rules, correct? And so for the purposes of the APS rules, there's substantiated finding. But I think what you're probably trying to get at a little bit is, and correct me if I'm wrong, but the preponderance of evidence is what leads to substantiated finding. And so preponderance of evidence is the level of evidence necessary in a lot of other civil matters. So for example, child welfare cases. The department also runs several economic security programs, and so if an individual wanted to appeal or had a concern about their right to a certain food assistance type, preponderance of evidence is a level of evidence in a lot of other civil stuff in Colorado.
And this is Jim Tadden again, and I think that's probably the issue that I have is it seems to be mixing two different burdens of proof. Preponderance of the evidence is different from substantial evidence.
Right, and I have it here in the
Mindy,
packet.
could I just interject for just a second? I wonder if this is this specifically related to Rule Packet 2 or 3?
No.
No.
No. It's just a general.
Okay.
I'm just trying to get a general sense of the discussion, because it seems like a lot of the discussion that I have is focused on a process that started based upon some sort of statement or allegation. That's what triggers all of the work here. And I could be wrong.
So I'll say there is no such thing as substantial evidence in the APS rules. So that's not a thing. It's not a level of evidence. So we go based on preponderance of evidence.
Okay.
But I think the terminology is, in order to substantiate a finding, APS would need a preponderance of evidence. So they would do the investigation, they would do all the interviews, look at all the information they need to, and then when they're ready to make a finding, if they have a preponderance of evidence, which that is the level of evidence, then they would substantiate it.
Okay. Thanks, that's helpful.
Yep.
Back to 101.
Yeah. Ooh. All right, I get control. All right, so we are going to move on, going backwards to APS 101. Ooh. All right.
Sometimes the projector doesn't understand the text. When that happens, I'll flick that light off. It'll make it easier to read.
I guess I have to click away. So I'm going to start real kind of high level and then dive a little deeper. We've got a bunch of slides to get through, so if you'd all be willing to hold your questions till the end, and I will try and get to the ones that we've identified here. In Colorado, not only APS, but there are several programs that are human service programs that are state supervised and county administered. And basically what that means is our Department of Human Services oversees these programs and is responsible for supervising them. And then our partners at our county departments of human services are the ones that actually administer them. So they're the ones that hire the caseworkers for APS and for child welfare. They're the ones that hire the eligibility technicians who do the economic security and food assistance type programs on the ground level. But then our department is responsible for making sure that they adhere to statutes, rules, policies, and regulations. And a little bit about APS specifically. The question has come up, is this a new program? When did APS come about? Well, actually, it's been in statute since 1983. But back then, the target population was older adults 65 and over. Then in 1991, the statute was amended to include the population of 18 plus at-risk adults. And I'll talk a little bit more about what that means and how that's defined later on. And we also wanted to note that in 2016, while there is no federal program for APS per se, some of you may be familiar that there's a child welfare program on the federal level and certain requirements federally around that. We did receive some guidelines for APS, and those were through the Administration for Community Living under the federal U.S. Department of Health and Human Services. And what they attempted to do with that was just to kind of survey all states that have APS programs and come up with some recommendations and things that the states could aspire to as kind of best practices. So Peg and I often have referred to that to say, what do other states do? What is, the recommended best practice? So over the past, I would say 5 years or so, there's been a lot of changes that have impacted the APS program and our statute. The first of which many are you familiar with is mandatory reporting. Colorado was one of the last states to get mandatory reporting, 49th I think.
Yep.
47, okay. And our mandatory reporting law in Colorado in 2013 included at-risk adults. So people in certain professions are required to report mistreatment of at-risk adults in elders, sorry. And I wanted to point out the specific language from that statute. Is if they observe or have reasonable cause to believe that an at-risk elder has been mistreated. You can see that at-risk adults with IVD were added to that in 2015. And there is a lot of confusion. I think the question came up earlier about who reports to who and when and how. And I will acknowledge that there is some confusion around that. And part of the confusion is there's a difference. If you're a mandatory reporter, you're required to report to law enforcement by law under these mandatory reporting laws. If you're not a mandatory reporter, you can report to law enforcement, or you can report directly to APS, or you cannot report at all. And so the other thing about the mandatory reporting law is that it requires law enforcement, when they get those reports, to share them with APS within 24 hours. So while you may, as a mandatory reporter, make a report to law enforcement, you should know that the law also requires that local law enforcement to report it to APS for them to screen in or screen out that report. I'm going to skip to the little bottom note here that says that the APS target population is not the same as the populations that are covered under the mandatory reporting laws. So specifically, mandatory reporting is if you observe or have reason to believe that mistreatment is occurring of somebody 70 and older or 18 and older with an intellectual and developmental disability, you're required to report. As we'll look in a few slides from here, and if you want to cheat, you can skip ahead on your handout. There's a slide that talks about what the criteria for screening in an APS case is. And our definition of at-risk adult in terms of whether or not to screen the case in is a little bit different. There could be overlap, there often is, but they're not necessarily. So for example, you can have an individual who's 75 who you observe some form of mistreatment of, and you would be, as a mandatory reporter, required to report that to law enforcement, and they would be required to share that with APS. However, once APS gets that case, they would look to our definition of at-risk adult to identify whether or not this is an at-risk adult that they would screen the case in. And if it's somebody who's has all their mental capacity, has ability to find services on their own, those sorts of things, they wouldn't screen it in because it's not an at-risk adult according to our definition. So that is an important distinction, and it's something that's a little tricky about our laws, but they are the laws, and so we follow them. And then we just went over this, but also last year is when the CAPS check bill passed. And so the expectation is that due process will start this July, and then those CAPS checks will be starting January 1st.
And Mindy, if I might interject.
Sure.
The mandatory reporting law, it was on the slide, but that's a criminal law. It's a criminal statute, and APS is not, we don't do work according to the criminal statute. So we are only bound by the APS statute, and that's what we follow. And so that's different. So
whoever's just talking is too quiet.
Really?
That's
the first time anybody's told me.
Said that, okay, before, Jerry.
This is Peg Rogers, and the mandatory reporting is in the criminal statute. It is not part of the APS statute, and that is a difference. So APS does business based on the APS statute and not the mandatory reporting statute.
Okay, so I'm going to move on to the state and county role, because I think there's been some questions about this as well.
is you'll see on the screen here the list of things that are the state role in terms of we established policy related to the APS program. We provide training to all the county APS staff. We provide technical assistance to APS and the counties. We conduct quality assurance and program improvement. We oversee that CAPS, that data system that we've been talking about, and then we also manage consumer inquiries. So if somebody has a complaint about a specific case, or say you're out in Moffett County and you have a question about a case that you're aware of, that you're concerned about, that you hear something about, you're always welcome to call Peg, myself, or Salisa, and our job is to review that case, and we would work with the county if there were any issues and how the county was handling that. And then in terms of the county role, oh, I skipped ahead, sorry. Quality assurance. So a little more detail about quality assurance, and this gets a little bit to the issue of how on earth can the State Department manage 64 counties? That's a lot of different groups doing the same thing. And these are some of the ways that we ensure consistency and standardization of the application of this program across the state. So we are in rule identified as the authority for quality assurance. Our unit, Peg and I in our unit, we do an annual statewide quality assurance on certain measures. And a quick example of that is last year we wanted to make sure our APS caseworkers getting the training that they're required to get per our rule. There's a certain number of hours, certain types of training that they need to get in order to be an APS caseworker. So we went back through our records. We asked them to maintain records of that in our CAPS database. We reviewed all the records, reviewed all the information, and great news, 100% of caseworkers last year and supervisors in APS received the minimum training that they're required to have by rule. Many of them went above and beyond. Some of them even doubled the amount of training. We give plenty of opportunities for them to participate in different training, but at a minimum, they all met the requirements. And can you tell us what the requirements are for those that don't know it? Yep, they're coming up. And then we do some informal case reviews and data analysis. Throughout the week, we have staff that we work with to get that done. And then we also have SeeStat measures. And so what those are is our department once a month requires each office to present on certain measures with our programs. And our measures around APS several of them have to do with timeliness. So again, just to give you a flavor, because we could be here all night if I start telling you all the SeeStat stuff, but one example of a SeeStat measure is timeliness of monthly contact. So our rules require that if there's an open APS case, the county must complete a contact once a month and document that in CAPS. And so once a month we pull a report that says, okay, for last month, were all the monthly contacts done. And so we have data that we present to our executive management once a month. Our goal for this is now 95%, that statewide we want to make sure 95% of APS cases are having a monthly contact. We realize that there might be, a little wiggle room there, like somebody's gone out 3 times, knocked on the door, and the person wasn't home, and so they missed the monthly contact. They did it 2 days after the deadline or something like that. That's where the 5% leeway comes in. But I think last month we did meet the 95% goal. So we're doing pretty well on that measure. And then ARD is a different unit within our Department of Human Services, and we recently received some funding to hire 5 people at that unit to do specific case reviews. And this is a really important aspect of our oversight of counties, so we're really happy to have this additional funding. And we're starting that up this year. In fact, Whitney, who's leaving, her county was the first county that got a ARD review, and she survived. Her and her team are still kicking. And basically what that unit will do is once a year at a minimum, they'll go out, review a statistically valid sample of cases in that county, sort of have a checklist of the various rules that are required, and make sure the county's doing what they're supposed to do. And then if there are any areas where they're off, that they didn't, comply with the regulations, they'll provide the county that information, give them, some information about how they could, focus on those areas. And then Peg and I and our team will also do some follow-up technical assistance if necessary. So lots of ways that we actually oversee the county work to ensure consistency. I will say that we know that nothing is 100%, right? Like not every single county is meeting every single rule requirement 100% of the time. I don't think any of us do anything 100. There's only one thing I probably do every day. I'm not going to talk about it, but we don't all do everything 100%. And so our goal here is to get as close to that as possible. And these are some of the ways that we make sure we do that. So now I get to talk about the county role, and the counties have a lot that they do for this program. Their caseworkers and their supervisors, the first thing they do is they receive a report and decide whether or not to screen it in. We do have criteria that I'll talk about in a little bit, but that's a very integral part of their job. They also conduct the investigations and the assessments if they do open a case. They provide casework services, try and hook up the at-risk adult with services that they need in the community. As we talked about, they coordinate with other agencies to do these investigations and put services in place. They also have some other community-related activities. They have a multidisciplinary team that they can convene. They do community education, and they provide on-the-job training for their staff. So they are very busy at the county level. I'm going to jump into the staff qualifications.
One thing before you move on. Just wanted you to note that nowhere on that slide did it say that the counties go out and do inspections or surveys of any type of facility or group home or host home. That is not our role. APS only goes out if we receive a report of mistreatment or self-neglect of an at-risk adult, and both of those criteria must be met before we can go out and start an investigation. So that was one of the questions that we had up on the board. Should we call that?
So the staff qualifications, APS caseworkers are required to have a bachelor's degree or higher in a human services related field. Our rules get into a little more specific about this, but these are some general highlights. Supervisors and senior caseworkers are required to have previous casework experience. They're all required to have state-provided training when they're a new caseworker, and that's that pre-academy workbook and also a training academy that we provide. They're required to be certified and complete the standard training, and then they're also required to receive ongoing continuing education every year. But you didn't say. Oh, I'm sorry.
Go ahead, Maureen.
This is Maureen. You didn't state on that slide how many hours the required training is. Right. So the hours, it would take probably 5 slides. So just the academy that they go to, how many days it is and how many total hours. Oh, sorry about that. It's 3 days, isn't it?
No.
No, the training academy is 5 days.
This is Peg, yeah. It's currently 5. Will be expanding to 8 days beginning in July.
So that's all the direct, formal, universal training, meaning everyone gets that together. The rest of the training is done peer-to-peer, more laterally, correct, on the job? That's what I understand from having gone to a lot of meetings. Right, so this slide that we're on now, in order to start casework, to be a caseworker, you have to complete the pre-academy workbook. You have to attend the training academy, which you said is 5 days, will be 8 soon. And then you also, the investigations training will be built in, so that's the additional 3 days added to the training academy. So that's the base training, in addition to having your bachelor's degree and human service related field and all of those kind of things. And then there is the continuing education. So once you are a caseworker, you're required, and that's what, I'm sorry, I thought you were asking about how many ongoing hours, because the way that that's broken out in our rule is based on FTE. So if you spend 100% of your time on APS and you're a caseworker,
then you're required to have 40 hours a year. But then it's prorated from there. So say you're half-time child welfare, half-time APS, or half-time eligibility in a county human service program, half-time APS, it would be prorated from there.
Well, I just think it's, oh, sorry.
Additionally, this is Peg, additionally, there is on-the-job training in the counties for those new workers as well.
Go ahead, Maureen.
Yeah, and just as a person with 2 master's degrees in education, 1 in special ed, I just find it really hard as a community member and parent to think that in 5 days someone can understand how to work with the diverse group of people that APS covers in their investigations. That's just, and it's something that the state board, those of people here on the phone or in the room, the state board's also concerned with that because there's not a lot of requirements around specific ongoing training. For example, how to deal with people with autism versus elders. It's just general continuing ed, and there's a lot of concern in the community that we have a lot of caseworkers who don't have enough training in dealing with the diversity of populations. So that's come up in state board discussions.
Thank you, Maureen. And actually that jumps into the continuing education. You can see there the variety of ways that we offer continuing education throughout the year. We do quarterly training meetings. If there are issues or common threads that are coming up, we address those on those meetings. We do a Tuesday topic. We do regional trainings, in-person trainings throughout the state. We invite in experts from certain fields to present to caseworkers and supervisors. And then we have just added this advanced investigations training. And so I'll circle back to the point around the specific populations because I think it is a good point that, you know, no one caseworker can have be an expert in all fields. And so what we try to do with some of these trainings, Tuesday topic, regional trainings, those sorts of things, is we'll have, you know, somebody from Alzheimer's Association come in and talk to us about that population. We recently did last year regional trainings on communicating with individuals with intellectual and developmental disabilities. We may have a Tuesday topic on somebody who is an expert in brain injury and talk to the group about that. And so we try and offer those opportunities throughout the year for those more deep dive kind of areas. All right. I have in my notes another example of that is last year we did a more in-depth training on investigating financial exploitation through forensic accounting. So that would be another example of a more deep dive training. All right, so here's where I circle back to the populations. We talked earlier about at-risk adults. So the APS statute is very specific about who this includes. And this is where that distinction between just because a mandatory report is required does not mean that that case is going to be screened in. So when APS gets a report, this is one of the criteria that they need to look at. Whether or not the person 18 or older is susceptible to mistreatment or self-neglect because they're unable to perform or obtain services necessary for their health, safety, or welfare, or they lack sufficient understanding or capacity to make or communicate responsible decisions regarding their person or affairs. And then we have a note here just indicating that there are some conditions that would increase the risk, but again, in and of themselves, these conditions are not would not qualify somebody as an at-risk adult under our statutory definition. So for example, just because somebody has been diagnosed with dementia does not mean that they would fit this criteria. They may be in the very early stages. And so if a report came in, even if it was mistreatment, if that person had these abilities, we would not screen the case in.
So just kind of point of order here. We had allowed Mindy 60 minutes to get through this. We've got 20 remaining, then an open question and answer for another half hour. We can do question and answer during the session, and I offer that to the group.
I'll make it quick.
Thanks.
Okay, this is Maureen Welch. I just feel the second point up there about lacking sufficient understanding or capacity to make and communicate responsible decisions, in itself a discriminatory statement for people with communication disabilities. My son does not communicate, he's not verbal. So based on this, he's already eligible if he was 18 or over. So I think that that in itself is very discriminatory, and I think that that needs to be evaluated in a different way.
And I'll just clarify, that is the statutory definition, so that's okay. Some of you may have seen our annual report. It's available online, but we do some pretty neat. We have a cool data person now who can do pie charts, which is awesome. And our CAPS database gives us the opportunity to pull data. So this talks a little bit about those risk factors that I just mentioned. And this pie chart shows some of the areas in which clients have had risk factors.
Right. These are the risk factors that the clients that we serve are dealing with, and so you'll notice that the largest populations are the medically fragile, frail elderly, and those with dementias or Alzheimer's disease. But also, maybe can't see it at the bottom, but almost half of the clients that APS serves have 2 or more risk factors.
Here's a little bit more data stuff for you, some more pie charts. We see here that, for example, 58% of our clients are female. You can see the client age breakout that while we do serve 18 and up, the majority of the APS clients are 60 or over. And then you can see the client living arrangements. There's a breakout. The majority are in the community, whether that's at a home or a host home, or is host home under facility or community?
We consider that for our purposes of data collection, we consider that in a facility because even though they're living in the community with someone, they're under someone's care through a program. And community is really they're living by themselves, they're living with a family member.
Can you repeat that? I want to make sure I understood what you just said.
For the purposes of data collection, we consider someone who is living in a home, whether it's a host home, group home, assisted living facility, long-term care facility, under the care of someone that is getting paid through a specific program, that we categorize that as a facility because it's not that they're living with a family member or a friend or living by themselves.
Was that defined in statute?
That is not defined in statute. That's how the APS program defines it for data purposes.
Okay, so we have several slides here on the definitions of mistreatment and self-neglect. And so I'm going to go through these fairly quickly because my main point here is to show you that these definitions are included in statute. And so for those in the room, you have the handout. For those on the phone, you're welcome to find the materials on the link on the public meetings calendar. I'm going to sort of bring these up on the screen, but kind of go through them fairly quickly because you're welcome to kind of study them and ask any other questions once you've had a chance to read through them yourselves. So our statutory definition for the purposes of APS of abuse means any of the following acts or omissions committed against an at-risk adult. And so the non-accidental infliction of physical pain or injury, and then it says as demonstrated by several factors, or the confinement or restraint that is unreasonable under generally accepted caretaking standards. And then the last one is subjection to sexual conduct or conduct classified as a crime under the criminal code. And then moving along to caretaker neglect, again, this is the statutory definition for the purposes of APS. Means neglect that occurs when adequate food, clothing, shelter, psychological care, physical care, medical care, rehabilitation, supervision, or other treatment necessary for the health, safety, or welfare of the at-risk adult is not secured or is not provided by a caretaker in a timely manner with the degree of care that a reasonable person in the same situation would exercise, or when they knowingly use harassment, undue influence, or intimidation to create a hostile or fearful environment. And self-neglect, as defined by our statute, is an act or failure to act whereby the at-risk adult substantially endangers his or her health, safety, or welfare or life by not seeking or obtaining the services necessary to meet their essential human needs. And then finally, we wanted to note that neglect, both caretaker neglect and self-neglect definitions, exclude certain things that are necessary to uphold somebody's advanced directives. So for those who are familiar with advanced directives or a palliative plan of care, things like resuscitation, cardiac pacing, mechanical ventilation, or artificial nutrition or hydration. So this is if somebody has done an advanced directive related to this, then it would not be considered caretaker neglect. And then finally, the definition of exploitation is an act or omission committed by a person. And then I'm not going to go through and read all of these because you can all read them on your own. But I think the point is that there are very clear definitions in statute. And so this next slide is the reporting decision tree. We wanted to, again, provide some clarity for folks on what happens when a report is made to APS. And so you'll see in the first box there that all calls that are made to APS, APS does take all calls. Some of them come in through law enforcement. Like I mentioned, if a mandatory reporter contacts law enforcement and then law enforcement must share that report within 24 hours, some calls come directly to APS.
And this is Peg. It also should be noted that APS has a requirement to share all reports it receives with law enforcement within 24 hours. So that requirement is a reciprocal requirement.
Per statute. Per statute, did you say?
Yes.
Okay. And so if the report concerns an at-risk adult, based on the definition we shared earlier, and mistreatment or self-neglect, then that report will be screened in for investigation and case planning. If the report is not concerning an at-risk adult, that 75-year-old that has capacity to make decisions and take care of their own needs, that's the one that would be screened out. Or if there's no mistreatment or self-neglect. And so a kind of common example that Anne from our long-term care ombudsman can relate to is I work in a nursing facility, I'm preparing a snack for somebody, I accidentally back up and step on the little old lady's toe by accident. And there's no harm done, she's fine, but I want to make sure I'm doing my due diligence, so I call law enforcement, hey, I wanted to report mistreatment. That would not be screened in because it's not mistreatment for our definitions. And then finally, once a case is screened in, it becomes a case, which means that APS would go out and do an investigation. We would also do an assessment of that individual's needs and also begin some case planning to get services in place to help them. And then if it's screened out, the county may provide other information or referrals to other services or supports to that person. This is a little bit more getting into the detail of how we would evaluate every report that comes into APS statewide. That we collect information from the reporting party, like what the allegation is, and information on the at-risk adult that's listed here. And then the county department would actually evaluate the information in that report to determine whether it meets the criteria to become a case. So again, reiterating, the allegation must meet those definitions for mistreatment or self-neglect, and they also must meet the at-risk standard based on the rule definition. I think I'm going to pull some rough numbers off the top of my head, but in terms of the percent of reports that get screened in, we're roughly 38%.
We fluctuate between 35 and 40%.
So there are a lot of reports that are made to APS that don't actually end up getting screened in for these reasons. Reiterating the point that APS does not make random visits or inspections. We're not going out into community living situations or facilities. and doing surveys. However, in the course of an investigation, if we find out that there's potential mistreatment of another individual, APS will make a new report and investigate on behalf of that.
Jim?
This is Jim Teton. The APS report decision tree is triggered by an allegation. Is that correct?
Yeah. Let's see if I can do this. That original report, yes, if somebody calls APS, that's the report that's made.
Okay.
Or if somebody calls law enforcement and law enforcement is then required to share that with APS, that's also how the report is made.
Okay. So everything's triggered by an allegation. So before there's a report, there's an allegation somewhere.
Anne, did you wish to chip in?
Separate point, so if we
Oh,
wanna.
I'm sorry.
So this is Peg. Yes, someone has observed or they have reason to believe that someone is being mistreated, and so they call law enforcement or they call APS to report that so that someone can get out there and make sure that person is no longer being mistreated.
Okay, thank you.
And that's all APS does. If we don't have a report, we don't go out.
Okay.
Go ahead.
You go ahead.
No.
Your hand was up first.
You must have eyes in the back of your head. Well, Mindy, but we have evidence to the contrary that we're hearing from the community that even when law enforcement does the safety check and writes no report, that APS still comes forward and charges with an investigation. And, Rob Hernandez speaking, but we can talk more about that because we've got specific, very concrete examples from family members that this has actually happened. So when law enforcement says there's nothing to the report, the individual is safe, and we're not talking about just the safety check, but people higher up in the law enforcement chain that have made that determination, but then that's not been satisfactory enough for APS. So I just want to be able to say that there are examples that is to the contrary.
So if I can answer that question. APS is required to do an investigation whether law enforcement has done an investigation or not. If there is alleged mistreatment or self-neglect of an at-risk adult, APS is required to do the investigation. They are not allowed to rely solely on an investigation conducted by law enforcement or a welfare check done by law enforcement.
You've had another question, but I just want to say that we're hearing evidence to the contrary where they move swiftly and they're retaliatory. But I just thought I would throw that in because it's just when law enforcement says there's nothing here, we've talked to the individual. But it's Rob Hernandez, Jerry. Sorry about that. Can you hear me?
No.
I don't know if that's working.
Is it?
Oh, this might not be working.
Howard,
Can you hear me now? I guess it's not working.
Do you mind coming to?
Here, this one works.
Okay.
At least we found out.
thanks, Jerry.
Jerry, can you hear me now? It's Rob.
Yes,
Okay,
thank
good.
you.
I'm speaking directly into this little bitty microphone. But what I was saying to Peg Rogers is that law enforcement does their safety check if they get a call, and yet if they determine that the individual is safe and there's nothing there, in other counties, they generally say, we're done, there's nothing here, and that's what they will let APS know. However, APS still continues to go down their decision tree, even though law enforcement says there is nothing here whatsoever. So I just wanted Peg to know and everybody here to know that APS goes down a decision tree based on whatever suspicions that they have. So this is what we're hearing from families, is my point, and it is happening, Peg, because this is what we're hearing from the community.
And Rob, as I said, Jerry, can you hear me?
Jerry, can you hear Peg?
Barely. It's hard to hear Peg.
Oh, look, I gotta hand her the microphone.
I'm telling you, nobody ever says that about me, Jerry. This is good. Thank you, Pep. As I said, Rob, APS statute requires that Adult Protective Services complete an investigation. If there's mistreatment or an at-risk adult, we are required to do an investigation. It doesn't matter whether law enforcement has done a safety or a welfare check and said they think everything is fine. We have to follow our statute, we have to follow our rules. So those counties that are continuing to do that investigation are operating within statute and rule.
Except though that we're hearing that even though the residential service agency does their own investigation, says there's no substantiation.
It's the same thing. It's the same thing with the residential service agency. APS has to do their own investigation. If you have a specific case that you'd like to talk about, we've asked you many times to provide that.
That's the problem, Peg, is that people don't feel safe coming forward. We've tried to go to families and say, "Oh, will you come forward?" They're scared.
People have called me many times about concerns that they may have with the county. We look into what the county's doing. We make sure the county is doing things right. And there has never been anybody that's reported back to me that there has been retaliation. So again, give us specifics, we can look into it.
But how do we create that safe place that Maureen's talking about where they feel like there won't be retaliation from the agency?
It is our responsibility and our job to make sure the county departments are doing things correctly.
And if they're not, then what are the
Then we talk to
consequences?
the county and we deal with that.
And do they follow your recommendations? I mean, do you have the teeth to be able to say you're doing things wrong, you need to correct that? Sorry to get down this path, but you know, it just Peg triggered the whole series of things, so.
Yeah, I'll just that one question and then we are gonna
Sure,
move on because then we'll have some time for questions at the end. So in terms of the repercussions or the follow-up, when we do receive a complaint, we reach out to the county just so everyone's clear. We also review the information in CAPS. If we identify, you know, let's take an example of say the county screened something in that they shouldn't have, right? We will have a conversation with the county, we'll provide technical assistance. If we have the authority to take some follow-up action if necessary, but oftentimes we prefer to try and deal with it through technical assistance and things like that. So counties are required to meet the statute and the rule requirements. So this next slide, APS priorities.
Excuse me, the next slide is illegible.
I know.
The whole middle of it is you can't read anything but a few, no, not that one, the APS priority.
Yeah. Can you do the background differently?
You can't read that at all.
I'm trying to.
Bummer, guys. This is already. Oh, here we go.
No.
It might even be answered.
Yeah, you should be able to
as we
do
go
that. There.
Yeah, I'm looking for it.
It's just as bad.
Yeah, we're working on it, Jerry.
Hang on.
Okay.
We are seeing the same thing, Jerry.
Oh, thank you.
If I could read it, I would start reading it. So while
You
they're
wanna
working,
skip it and go back to it later, maybe?
we're getting there. All right.
That's
Thanks.
working. That
Nicely
works. Thank you.
done.
All right. Problem solved. So here.
Problem solved?
Cost.
No, it's just reloading.
All right, so these are the priorities for APS. I'm going to go through all four of these. So confidentiality, we have very specific requirements in our statute related to confidentiality. All aspects of the report and case are confidential and can only be shared with a court order. There are some exceptions to that, and they are all laid out in statute. Also, consent. Adults who have the capacity to understand their decisions will have the right to refuse protective services. We see this oftentimes in self-neglect cases, right? Just because it's an at-risk adult and they're self-neglecting and APS goes out and conducts an investigation, the person can always, say, no thank you. Self-determination. Adults who accept protective services always have the right to decide which ones they would like to receive. So they might say, yes, I'd like your assistance with this aspect, but not with this other. And then finally, least restrictive intervention. And this basically means that APS provides protective services that are least intrusive to provide for the client's health and safety. We should also intervene for the shortest time possible. All right, the next few slides, and then I think we should wrap up fairly soon, but
You might want to just make a quick check through the question list.
I think Peg's kind of noting
Yeah, I think if we keep going, we'll get to some of them, the last ones that we haven't gotten to.
So an investigation involves different things. It includes interviews of certain people that have relevant information related to the allegation. So people like the reporting party, the at-risk adult themselves, other witnesses, and the alleged perpetrator. And APS will do the interviews in person with a few rare exceptions. We typically don't announce the visits. And then the adult and other witnesses and collateral contacts will be interviewed alone wherever possible. I know there has been a question, do you always interview an at-risk adult alone? If they request to have somebody with them, we will definitely make that accommodation.
I haven't heard that in the community.
And so during the investigation, the caseworker will also collect evidence and supporting documentation, and you can see some examples of that here. Depending on the allegation, for financial exploitation allegation, it may be bank records, it may be things like that. And as previously mentioned, the investigation may be conducted jointly with other agencies conducting investigations. Once the caseworker has completed the investigation, they'll review all the evidence to determine if the allegations are substantiated. And there's that preponderance of evidence standard that's in our rule. And then the findings are discussed with the APS supervisor, so we have a check there. And starting July 1, all findings will need to be approved by the APS supervisor per rule. And people who are substantiated in a case of mistreatment will be provided those due process rights that we talked about before. That is pending the state board's approval of our rule packet that's going before them in April. But provided that rule packet is adopted by the state board in its current form, that's where that due process will begin.
Maureen?
So the right to appeal, that's upon the notification, when they get notified that they're substantiated, correct?
Right, it's not in current rule, but if that packet.
Rule packet 2.
Right.
Yes. So my concern is that there's no notification except for that. I feel, and we've discussed this at state boards, I know a lot of people here didn't make it to state board, that really someone should know their rights before the investigation starts. Okay? Everyone involved, whether you're part of the allegation, whether you're the person that's at risk. And right now, there's no notification except upon substantiation. So that basically makes those in the community feel like they could be under investigation anytime because there's no requirement to notify. Does that make sense? So anyone who could fall in that at-risk category could be under investigation anytime because you're under no obligation to notify anyone as an APS employee that an investigation has been started, correct?
And to clarify, we're not investigating the at-risk adult. So we're investigating the alleged mistreatment.
Right, but the persons involved in the investigation are not notified at the start of the investigation that something is happening and they have rights, correct?
So they would be notified, like if we were to be going out to interview them or something like that. Then
But they don't get these are your rights?
No.
Okay, that's an
That's
issue
not
to me, and
required.
that actually came up in state board too. State board member really felt like that was highly questionable, that there's no notification of rights to anyone involved.
Got that noted. And then the question around preponderance of evidence, that is the standard used by APS and Child Protection in Colorado, and there are 39 other state APS programs that use that standard, as well as many other civil areas in Colorado. I'm going to talk a little briefly about the data that we have around findings. And so you'll see in the pie chart up on the left, those are the allegations. Those are the allegations that are made last fiscal year for APS. And so you'll see the highest percentage is actually in self-neglect. But then about 25% each for caretaker neglect and exploitation. And then on the bottom, this chart is a little bit difficult to, I kind of always have to reorient myself to it. But in each of these categories, this is the percent of the allegations that were substantiated. So for example, of all the caretaker neglect allegations, 23% of those were substantiated. So you'll see that self-neglect is the highest. So of 100% of self-neglect allegations last year, 47% were substantiated. And then in terms of this findings data, again, the pie chart is the relationship of the substantiated perpetrator to the client. And so in over half the cases, it is a family member. But then there's also the categories of agency, professional, community member, or unknown. So those are the sort of high-level categories.
And just to let you know, the unknown are things like when people get involved in a scam, in the grandmother scam or the Nigerian lottery scam, and we are not able to identify who that perpetrator would be.
Is there another word you could use besides perpetrator?
So this is the word that's used in our rule, and so that's the basis for the use of that word.
And these are substantiated, so these are perpetrators. When we
No,
are
it's more
talking
than-
about someone who is alleged to have done something, it is an alleged perpetrator.
You're saying someone who is substantiated. Sorry, this is Maureen. Someone who is substantiated more likely than not the thing happened. That to me is not a perpetrator. That's like a weather report. Okay? Perpetrator is when you have gone through the criminal system. I really think we need to examine that in rule, and I'll bring that up at the next state board meeting. So thank you for mentioning that it's in rule, because that is completely inappropriate to use that word there. A substantiated person, more likely or not, that thing happened. That's not the same as a perpetrator. Thank you.
All right, and then on the bottom you'll see the relationship. So an important part of the APS work is also the assessment. And so this is conducted to determine the at-risk adult safety and risk factors. And we just recently had an assessment tool that was validated with some collaboration with partners at Denver University, University of Denver. This is not used to diagnose
Let me stop you.
conditions.
Who are those partners at the University of Denver? Can you let us know later offline to identify those partners?
Yeah, so we worked with researchers to validate this tool.
I'd like to know who those researchers are, and I'd like to see that research if that's available.
I made a note, Rob.
Please, because I think that's important. When you're quoting research and you're quoting them, it's important that we be able to review that to see if it's viable and what type of research was done and what was the methodology and was it objective.
Sure.
So did somebody write a position paper or a supposition, or did they actually do a research paper that had methodology with viable objective data?
Sure. And I agree with Rob, because when you look at the pre-academy workbook, the Paul book, all of the data reports that are cited are work with elders, not with IDD. So to me, that made a lot of difference to know where those data points came from, because working with elder population is different than the IDD adult population, very different.
And so the assessment tool has the impact of mitigating services. So we assess it by evaluating various risk factors in these 7 key areas. So the caseworker would go through this assessment tool and use this as a guide, and then an important distinction is that the adult's risk can be mitigated, and safety can be improved with appropriate services. So there's the example of an adult with a minor ambulation impact, like an unsteady gait, would be safer with a cane or a walker. That's an example of a mitigating factor. And then ultimately what the assessment does is it helps the caseworker identify what are the services needed to assist. So in a self-neglect, situation, this tool can be very helpful to identify what are the things that we should be looking for in the community to support this person. So this slide talks about case planning, and the items listed here relate to how the caseworker would go about conducting the case plan. The client must consent to the services, and then that self-determination piece factors in here as well. I'm gonna pull it up.
Well, I need to fix the next slides that are coming up as well. So this one we're not going to take the time to fix. These are just kind of the network of services that APS uses. And we have it on ours, so we can tell you.
Yeah, I can tell them while you fix the next one. If I can read it. It's getting late in the day. So some examples of the network of services are medical, long-term care facilities, local services, community, personal care, religious community, area agencies on aging, family, friends, and support, and the federal and state government programs. So those are just some of the areas that an APS client might be referred to for additional support.
This got really messed up when I put it up here in Google. I don't think this is going to work.
So Mindy, just looking at the list of questions, I feel like we've covered many of them, but not all. And I wonder if it makes sense just to pause right now and use the remainder of the time for Q&A to talk about what's most important to those in the room. And we haven't had any questions from those of you on the phone. So as we start our Q&A, we may use some of the material that Peg is fixing right now. Are there any questions from the phone?
Yes, this is Jerry. My question has to do with the information that would be given to an individual who's involved in an investigation, like the person who, we'll say, was harmed. I wanted to know what the rule says about their being able to get a full and complete copy of the file involving the investigation. Are there any limits to what the individual can receive? And can you talk about that for a minute, about how thoroughly they're allowed to be informed according to rules?
Sure. So right now, as we talked about earlier, there are certain requirements for confidentiality in statute. And the way the statute is written is that all information about an APS case is confidential and not available to anybody without a court order. There are several items in the statute that say except for, and it's something like, one example is when they're doing a joint investigation. So information from an APS case, if law enforcement and APS are investigating together, APS can share information for that purpose only. Or when doing some service planning, if APS needs to communicate with another agency to get services in place for somebody. There are very, very specific exceptions to that court order in statute. One of them, there is not one for providing the client a copy of their case record currently. So what has come up as we've gone back and looked at the rules around confidentiality is that we realized that that is not included in statute. That's something that the state board and others have expressed concern over, that they feel like it should not require a court order for the client to receive their file. However, currently, what is needed to change that is a statutory change. So a legislator would need to run a bill to change that in statute. So that's not something we could even change through the state board process and rule. That's something that's a statutory requirement.
So let me understand, you cannot change it in rule. It would have to go to like this year or next year's legislature to get change so that a person can receive that information without having them going through a court order, is that right?
Correct.
This is Jim Teton. What is the statute
So
that
it's
governs that?
26.
26-3.1, Part 1, so 101.
Others on the phone, any questions, Q&A from the phone? Okay, how about in the room? Thanks. So we've just been keeping a tick sheet of ones that have been addressed. They may not have been addressed completely to your satisfaction, so you can simply look up on the list and raise any of those if you wish, but ones that we haven't mentioned at all. Number 5, does APS take at-risk adults out of their living environment for the purposes of attaining guardianship? Mindy?
So no, and I don't know if there's a specific follow-up question to that, but again, the court is, and maybe this might help to hit on those guardianship slides to demonstrate how, do you have the clicker? Oh, yeah, I do. I thought you were doing it. Oh boy.
There we go. Yeah, for some reason these slides at the back got
Okay.
formatted.
So I'm just going to read this for those on the phone. So the APS statute urges but does not require a county department to petition for guardianship or conservatorship when the adult lacks capacity.
To make decisions and is in need of protective
Services. Okay. The county may petition on behalf of a family member who will become the guardian, or may ask the court to appoint a private guardian. And the county may also petition the court to become the guardian if there are no other appropriate persons willing or able to become the guardian.
Number 6. Oh, I'm sorry, I didn't know this was second.
Can I ask a question? This is always confusing, not confusing, but so what dictates capacity?
The court.
I can't hear what.
Sorry,
Did they say?
Jerry, this is Ann Patton. I said, what dictates capacity? I mean, to me that sounds like such a nebulous thing because someone can look at my son and say that he has no capacity when he in fact does have capacity. So,
So capacity is determined by the court. It is only the court, based on evidence and medical records, that the court makes that decision that someone, yes, does not have capacity and needs a guardian. Adult Protective Services uses some screening tools, like the SLUMS or the MOCA or the Mini Mental, to see whether or not that person needs further evaluation by a professional. So if we are going out and we're seeing someone who seems to come in and out, maybe doesn't remember us from visit to visit, if we're starting to see some signs that there may be some cognitive deficits, we can do that screening tool. But all that does is tell us whether or not we need to try to get that person in to see a doctor or a specialist to have an evaluation done. Not by APS, we don't make that determination. We leave that for the professionals. And then that evidence goes to the court if a guardianship is needed. But guardianship is one of the very last things that we look at. And it is absolutely the last resort. If we can find ways to provide for that person's safety using any other method, we will do that.
Maureen?
You keep saying we, and it's confusing to me if you're meaning you, the state, you, the local,
We
you,
use
the
the
who.
APS program.
Because really, APS is a local program, and everyone's doing it differently. So I think it's really hard when you use the word we.
So I'll address that. APS is a state program, and as we mentioned earlier, the state is responsible for overseeing and supervising the program. And so the county departments administer it, but the state supervises it. And so it's not an individual program, it's a state program that we oversee.
Okay, well, I know cases, many cases where the first thing APS did was get emergency guardianship. So to say that it's the last resort when it's the first thing they're doing, maybe that's the state's position, but what I'm telling you is people at the county level are not taking that position. So that's another disconnect that's concerning to me. So I appreciate Ann's comments, and my other thing is back to that discrimination piece. My son's nonverbal, so does that mean that he doesn't have capacity? I think it's really important, and I don't know if we can get maybe some legal advice on how to write these things without being, I just see a lot of flags here as potential problems, and you know, none of these tests my son could communicate to answer, so automatically he's not capable. That's just inappropriate. So I don't know if you have another document that you share with your APS people on how to determine things or how to refer things, a flow chart or something. Would that be helpful to those of us in the community that have a lot of fear around this?
Ann?
You bet. Ann Meyer, State Long-Term Care Ombudsman, but not a lawyer, so no. Can't offer legal guidance. Long-term care serves primarily an elder group, but not entirely, and so I've been sitting here trying to look at it through the lens of IDT, but also elder, also people short-term rehab, older folks. I've been writing a thing on brain injury while sitting here. There are a lot of people that kind of fit into this category. I appreciate the intricacy of trying to balance the need for protection and support. You know, we don't want a heavy hand, but we don't want the state to be allowing neglectful practice, abusive practice. And so really trying to strike the middle ground with a lot of this language, it's hard. It's hard. Working at Disability Law Colorado, I also find it interesting because different advocacy groups, different programs really have different understandings of where that needle sits, that decision point, the fulcrum of what that looks like. Capacity is different than the word up here. We're all getting tired. In the world of people who are older, we actually struggle with really wanting APS to take guardianship because there is no one. We're excited about the Office of Public Guardian in the pilot program and hope for good things, hope for balanced decision making when that comes about. So I just appreciate the sensitivity that all of this group brings to this law is intended to protect, do the most good for the most people wherever possible across Colorado. It's hard. The task you've taken on is hard.
Jim?
This is Jim Teton. I agree with the goals. I agree with the purpose. The more I listen and the more I learn, the more troubled I am by the proposed regulations. And I understand that, you know, the statute essentially guides the rules and the regulations, but I'm confused by some of the language. You know, the substantiated allegations, use of the word perpetrator. If Maureen is caring for me and someone makes an allegation with regard to Maureen's treatment of me, and I'm the individual that is being harmed, I have to hire an attorney to find out what's going on? Do you know what attorneys cost here in this great city? And how am I going to know? I have a traumatic brain injury. What's going to trigger that for me, or my family member? Or if it is a family member, is my older brother going to be concerned? You know, it's just, I understand the goals, I understand the purposes. No one wants anyone to be harmed. No one wants anyone to commit crimes. There's a reason why we have an Office of the Public Defender. There's a reason why we have Miranda rights. You know, everybody that's kind of what my reaction, the more I learn and the more I try to process the actual language, it isn't as simple as I think we believe it to be. And while we all want to help people, if you make one error with one individual or one family, it's bad. That's why we have the Innocence Project, to keep people who were wrongly convicted and sentenced to death off of death row. Guess what? We got it wrong. That's my concern.
Yeah.
You know, it seems to be civil. It seems to be guided by the common good, but it really has the feeling of criminality to it, and accusations, and language of perpetrator. If you look at the definition of perpetrator, I'm going through the definitions, I'm reading, it's troubling, so.
Thank you. Thank you for sharing that.
Could I just butt in for a moment? So we got started about 10 minutes late due to just logistical sort of things. We do get booted out of the building at 8, if you guys will recall from the last when the lights go off. So I propose we hang on. If anybody needs to go directly at 7:30, we'll put them to the front of the line for a question. And then if those of you can hang around for another 15 minutes, but then we'll use the last 15 minutes to safely exit the building before the lights go out. So call. Anybody need to leave right away and want to go to the front of the line? Anybody on the phone? Okay, then Mindy, number 6 was the next item that we had not addressed.
Okay, so the question was around does APS on the county level, does the caseworker force the at-risk adult to sign a paper? And
Louder, please.
Does APS force the at-risk adult to sign a paper and then remove all their rights? And so there is nothing in APS statute or training that talks about a person signing a piece of paper so that we would remove their rights. Maureen.
I just had a question because we're talking about removing rights, and I know that we have someone from disability law here, and I don't know if she can speak to it, but I'm wondering what the role as a protection advocacy agency is for individuals that might need representation. I know that you have specific program areas. I'm just wondering, the question that Jim brought up. The question that Jim brought up about people having to hire an attorney is concerning to me. Where do people go if they need legal representation and they can't afford to get it themselves? And then my second question would be, if someone wants to file a abuse, neglect, or exploitation complaint against an APS worker, where do they go?
Well,
Do you want to take the first
sure,
one?
I can't. Ann Meyer, State Long-Term Care Ombudsman. Only to the first question, not the second.
Okay.
Complicated. Disability Law Colorado does indeed house the protection and advocacy system. That's actually a interlacing set of federal legislation that works to protect and promote the rights of people with disabilities. So if your question is about if somebody feels unjustly accused, where would they go? Certainly, probably not disability law.
No, a person with a disability
But if
wanting help.
And they could certainly approach Disability Law Colorado. You're probably aware that the need is great and the resources are few, so they end up setting up priorities. And I say they because I don't work in the protection and advocacy side. I work in the ombudsman side. So that's a little different, and I would hesitate to get too far down the road of committing my colleagues to a thing that I'm not clear what they do, where they go with that.
So protection advocacy is based on your capacity and whether you feel like that's an area of interest for disability law to pursue.
I might ask you to say that in a different way because I'm not sure what you mean.
Okay.
Protection and advocacy is
federal term.
Right.
Okay. Well, I've come to disability law with different people needing help, and we've all been turned away. Mm-hmm. So the reputation in the community is that we get turned away. So where do we go if we need help and a person can't afford? That's my question. And that's when all this APS stuff becomes a power issue. because they have all the power to take away, and I have no way to defend myself as a person at risk. And that's a not a democratic way to go about something. We have public defenders in the criminal system. Where is the legal help for someone with a disability, at risk, whatever they fit in this category? Where do they get help? There's nowhere. I'm not going to call up Salisa if I have a problem with my caseworker. It's too dangerous. This is the thing, and I think disability law, if you could take this back and just say, look, this is an area of need. See what they say. Because I would think that, I think it's a $2 million contract you get from the federal government a year, that somehow there needs to be something in there to help people. $2 million a year from the federal government. Disability law needs to help the most vulnerable who are in this situation. So I don't know if you can take that back and get to me, but
I will be happy to
it's critical.
take
critical.
the question back.
Thank you. Well, then my second one was, where do we take it if someone wants to complain against an APS worker?
This is Eric. I mean, I guess saying that you should call your county APS, probably not happy with that. I mean, the other avenue is to contact law enforcement. I mean, those are the two main places that people would go if they're trying to report allegations of mistreatment against an at-risk adult. I mean, I guess just sort of a point of clarification, if the person, if you're saying, if for example, if you were the person saying you wanted to report.
Yeah, I'll give an example.
Yeah.
I was put in a room at my day program and told by strangers that I needed to sign this piece of paper and I couldn't leave the room until I signed it. And I signed it, and then I learned later that that put me into emergency guardianship, and APS is now my guardian instead of myself. And I think that action, I can't read, but they made me mark the paper. I want some representation. I want to complain against that worker. Where do I go?
Well, as we've said many times before, please feel free to call us so we can investigate the case. I know you don't want to do that, but that's the only thing that, as a department,
Right.
we have to offer.
Well, other departments have it set up differently, though. Take PEP. If you have a problem with an agency, another agency investigates to create that firewall. There's no firewall here.
Can you
There's
give
no
an example
firewall.
when they have another-
CDPHE investigates complaints against service providers that are Medicaid providers.
I think-
There's firewalls there, and there's no firewall here.
CDPHE actually regulates those providers, that's why they do it. Because the facilities at least are regulated by that department. So that's why they are the place that houses that activity.
It's a conflict of interest, that's all, to go to the same people that have the power over you. When you have no power, you have no legal representation, so you can't give any help,
Well, the only thing I would reiterate is that we are the supervisor of the system, so we don't have power in the sense that we're not out there the ones making decisions. And you have made the assumption that if you tell us something that is going to have, you're going to be retaliated against. I fundamentally disagree with that, but until you actually give us a case that we can look at, I can't prove that to you. And so you can continue to say that we would retaliate you, that you never actually give us the opportunity to show that that would not be the case. So I don't know what to do with
I know
that.
it's a conundrum.
Yeah,
I
it
can't
is.
send someone into the mouth of the tiger, I just can't. I cannot do it in good
And
word.
Eric, to add what Maureen is saying, in one particular case where exactly like that happened, an email was sent directly to Reggie Beecha and leadership, and nothing happened. They're still hearing crickets. So there's a concern that that did happen, where they actually put in an email and forwarded to leadership in this department, and nothing occurred, nothing happened. No response, not a phone mail, not an email response, absolutely nothing.
We are aware of that complaint. However, there was no case, there was no specific information attached to that, so we can't investigate something that's sort of global and arbitrary. We need specific information on which case you're talking about so that we can follow up.
And there's been more than one email sent to leadership, I will tell you that.
Right, again, without the specific case information, we can't follow up. But just to clarify on number 6, because I think we probably need to move on a little bit. So APS would not force somebody in a room, force them to sign a paper, and then that would trigger guardianship. So the court does decide guardianship. So signing a piece of paper, the at-risk adult signing a piece of paper, just for clarification purposes, does not create emergency guardianship or guardianship. The court would make that decision.
But remember, Mindy, as Commissioner Johnson said, but the courts follow what you tell them to do.
Right.
That was an important point. So if it's important that the whole structure be looked at before their jump is made to that. And that doesn't happen in Denver County. Because we've heard, again, I'll say this, we've heard from more than one very well-renowned, very well-known, experienced probate guardianship attorneys have told us that Denver County is the one county where we see the balance between law enforcement and APS. Is that if there's rational decisions being made, they look at all the facts, they just don't take off over law enforcement and jump to conclusions. And so that's why we see this in Denver. We met with Maureen and I met with a number of different people as well as Jim to make that determination. So that determination came from people out in the community who said Denver is probably the one rational county that really is probably doing it the way that it should be done.
This is Eric again. Does Denver do a lot of guardianships?
Yes.
Oh, they do.
Yes, we have some.
Yeah, by proportion.
So Mindy, there were 3 questions at the bottom that were new at the beginning. So, and given that the folks on the screen won't see that represented, if you could just read them as you deliver.
So I will say on reporting, like I mentioned when I talked about mandatory reporting, it is confusing, and we recognize that. We have to work within the laws that the state has for us on mandatory reporting and the options for folks to report mistreatment of at-risk adults. And so we do have a training online. It's an online training available for mandatory reporters that sort of talks about here's where you would report to law enforcement, here's how you might report to an APS. It gives a general sort of framework of those laws and how those are implemented. I think we've tracked the number of attendees, and there's over 40,000 people over the past 3 years, I guess, that have taken that. And so that option is available. I think this is also a good idea that if we have some sort of a simple flow chart too, that might make sense. I will say it's not going to be pretty because it is complicated like I described. So that's something we can work on making available on our website. And then where do people go to discuss the details of cases? A safe place. Again, I think we've touched on that many times. The avenue for that is to report it to us at the state. If there is specific information, then we can follow up and ensure the county is doing what they're supposed to do. And then finally,
Why are emergency room or emergency department visits considered harmful?
and emergency room visits cannot be the sole source. So when an APS caseworker, when a report comes in, again, that report is evaluated for both the at-risk adult criteria and the mistreatment criteria. If it's determined that a case should be opened based on that criteria, there are many different aspects that the caseworker would look at in terms of interviews, documentation, information, to assess the information in that investigation to make their findings. So again, without a specific case, I don't really know what this refers to, but this would be one factor.
Yeah, I'm gonna step in here. So a single emergency room visit is not necessarily an indicator of mistreatment. But if someone has multiple repeat, and that's what the PAW said, multiple visits to the ER is an indicator. It doesn't mean it happened. It's just one of the red flags that we ask people to look for as they're making sure that the adults in their care are not being mistreated.
Point is if you have orders, standing orders from a physician, from a PCP, and a hospital emergency room doctor saying, bring the individual in because this is the treatment, because we expect this condition to happen because it's chronic.
I'm sorry, I'm going to stop you so we can get to any other questions that are left.
Well, let me finish because I don't stop you.
We've gone over this,
but
we're not going to get into individual, specific.
But this is a trend we're seeing. And
Are there other, we are bumping up
Peggy,
against
always
you.
interrupt me, and
Hang on.
I'm kind of getting tired,
Rob,
to be honest
Rob,
with you.
We are
But
bumping
you
up
let her
against our
finish, but you don't let me finish.
Rob actually was about to. I just wanted to challenge Peg's point of whether there are other questions that other people want to go after. Does anybody else have a question? Okay, so please continue, Rob.
You know, because the follow-up is my point is that we're hearing numerous instances where you have APS agents kind of hanging out in the emergency room and asking doctors to review their notes and to change their notes, and they're saying, wait a minute, we're doctors, we're not social workers, we're not APS investigators. we're seeing that problem. So that's where the overreach is coming from, Peg. And I know you're going to disagree with me, but when we have people that are hearing that and they're following a doctor's orders, take the individual to the emergency room because that's the protocol for the chronic condition, that should not be a factor and that should not be flagged, is my point.
Give us a case, we'll be happy to look into it. This is Eric.
But it's a trend. It's not a particular case. It's a trend, Eric. That's the problem.
No, but the reason
We are not aware of any
please,
trends.
please. The reason we want to look at a case is to validate the information you're providing to us. We have told you already that we have a quality assurance process in place. We reviewed, even before the Administrative Review Division, we were reviewing samples of cases in counties across the state. We have not identified the issue that you've brought forward. Because we were looking at a sample, obviously that means we haven't looked at every case. There could be cases out there that represent these problems. The only way that we know of to investigate that is for you to give us an example so that we can look at it.
And back to the safe place, Eric. Back to the safe place where people feel there won't be retaliation.
And I would say my only reply to that is that I don't believe you have any data or evidence to suggest that any of the three of us have ever retaliated against anyone.
It's a culture of the department is what people feel.
Maureen?
Yeah, and I was just going to say, so right now, visiting an emergency room itself is considered a abuse or neglect flag, is that what you would call it, or an indicator, or what would you say an emergency room visit?
This is Eric. That's not what she said. She said that if there was a pattern of people going to the emergency room, that could be a red flag.
Okay. Well, I brought this up actually at the HICPUF Affordable or ACC group PIAC because Dr. Keller was there from Children's Hospital and they were complaining about people going to the emergency room too much. And I said, you know what happens when I call the advice nurse at Children's Hospital where my son is seen for primary care? You know what they tell me? We don't have any sick visits today. Go to the emergency room. He's got strep throat. Every single time I call, if you call after 7:30, because they open the lines at 7:15, they don't have any appointments left. So that makes me into a pattern of abuse because my son gets a lot of infections. That's concerning to me. I think that there needs to be a certain level of judgment within emergency rooms because primary care right now is really hard. It's hard to find people that have openings. And when you're calling in the morning because you're sick, your kid has a fever, I don't know if you have children up there, but this is a case for healthy kids, not only people with chronic conditions. So I think the emergency room visits is something we should talk about more in another setting because it is concerning to me.
Well, and this is Eric again, just to reiterate something else that Peg said is that, again, red flag does not equal substantiated allegation, but
I would just hate for people not to go to the emergency room when they needed care because they were prohibited. That's all. I think taking it off the list as a indicator, whatever you want to call it, might be a good move for the welfare of our individuals.
then what happens with the truly at-risk adult who is going to the emergency room multiple times, not for a good purpose?
Because you have mandatory reporters there that can report those egregious cases, not the little strep throat that my son has gone into 4 times over the winter. It's different.
I agree, but again, getting back to a point we already made, the only way we would know about your son going to the hospital multiple times is if someone called us to file a report. We don't go out, we don't sit at the emergency rooms trying to identify potential cases.
But I disagree with your statement that it has to be on the list in order for a mandatory reporter to call, and there are other checks and balances in place.
Other last questions? Anybody on the phone have a last question?
Yeah, this is Jerry. I have a question. If we want to get a copy of the PowerPoint,
I sent it to you, Jerry.
We email, like, I don't know what Mindy's last name is, but if we email you, can you mail that to us?
You can tell her I already sent it to her.
Maureen says that she's already sent it to you, Jerry. But I think
the PowerPoint from tonight?
Yes, just now, or during the meeting I sent it to her.
During the meeting, she says she sent it to you.
How about the list of the questions? Like
Is that
the
on the
15
meeting?
questions?
We can add it to the public meeting calendar tomorrow.
Jerry, do you have access to the public meeting calendar?
I can talk to somebody later. I don't know how to. Mindy is Mindy's.
Mindy.kemp.
What? It's
Kemp, K-E-M-P.
K-E-M-P.
Yeah.
At State Colorado US. Okay.
Yeah.
I will email her with my question. Thank you.
Thanks, Jerry. All right, well then, we'll close the meeting. Do want to say thank you for everybody for your participation. The next meeting will be on Tuesday night, 5:30 to 7:30. Main topic is actionable feedback on rule packet number 2. All right, thank you all, and good night.